Major breaking news out of Portland, Oregon. A federal district court judge has decided that, quote unquote, large capacity magazines, which are magazines that hold more than 10 rounds, are not protected by the Second Amendment. And thus, the Oregon law that essentially bans, quote unquote, large capacity magazines is constitutional. Now, there's a lot to cover on this video. It's going to be painful, but it's going to be worth it when I point out all the countless flaws in this decision and why it's simply not going to stand the test of time. You'll see why in just a minute. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Amazon. Don't forget to follow me on @4boxesdiner if you haven't done so already. All right. Major news, but frankly, a foregone conclusion. Federal District Court Judge Karin Immergut, a judge in Portland, Oregon, has concluded that magazines that hold more than 10 rounds in modern semi-automatic pistols are not protected by the Second Amendment. This was a foregone conclusion. In fact, I think the best metaphor here for Judge Karin Immergut is that if I saw a 5-year-old boy running around with a chainsaw, and I saw that he hurt himself or someone else with that chainsaw, I would be sad and unhappy about the situation, but I would be like, I'm not surprised. Well, when I saw that Judge Immergut, Karin Immergut, handled this case early on, the way she handled it early on, I'm not surprised that this outcome is exactly what I predicted, which is she's not going to be good on this case. But let's go through and show all the different mistakes she made, because this decision, while long, it's 122 pages long, is completely wrong. And again, you'll mark my words, this is eventually going to get overturned and tossed out by someone down the road, probably the Supreme Court. You'll see. Nevertheless, let's start from the beginning. Who is Judge Karin Immergut? To begin with, it's unusual to find a Karen actually go Karen on the Second Amendment. Oh, pardon that joke. Nevertheless, Judge Karin Immergut has done exactly that. She has ruled against the Second Amendment and ignored Supreme Court precedent, despite the fact she is an inferior court as defined by Article 3 of the United States Constitution. Now, before we get into the details of all the countless mistakes she made, I want to point out something about her background. In addition to the fact that she spent literally for her entire career, virtually her entire career, working for the government in one form or another, most of the time as a prosecutor, mind you, including, by the way, a stint with the Department of Justice doing what's called Project Safe Neighborhoods, which is a euphemism for enforcing all of the federal gun control laws. Specifically, Project Safe Neighborhoods is part of the Department of Justice and part of the ATF. Oh, interesting. So she basically worked as a prosecutor for the Department of Justice and the ATF. Interesting. And what did they do with Project Safe Neighborhoods? One of the things they did is they did heightened enforcement of all federal laws with a renewed aggressive enforcement of federal firearms laws. So we know where Judge Immergut's point of view is here. Obviously anti-gun. It was clear from the start that I could tell she's out there in Portland, Oregon as a federal judge. And right from the start seemed to be terrible on this issue. We're going to talk about some strategic things. I think when you deal with these terrible judges in the future on gun issues, how you should handle that. I will do that for a separate video, but I will do a list of things how I would handle judges like this if I were trying such cases, but we'll deal with that separately. So to begin with, what was the question presented and what did Judge Karin Immergut decide? Specifically, the question presented, the key question I want to talk about today involving magazines presented was this. Can the state of Oregon limit the number of bullets to 10 that a law-abiding citizen can fire without reloading? And she said the answer is yes. She says, explained below, the Second Amendment plaintiffs have not shown that the Second Amendment protects large-capacity magazines, defined as magazines capable of firing 11 or more rounds without reloading. And even if the Second Amendment were to protect large-capacity magazines, this court finds that the defendants and intervener defendant have established that Oregon's restrictions on the use and possession of large-capacity magazines are consistent with the nation's history and tradition of firearms regulation. All dumb. All dumb. Now, before I get into some very specific things about legal mistakes she made, I do want to put this right up front. Because for those of you in the Second Amendment gun community, I think what I'm about to say is going to let you understand immediately just how absurd and baseless this 122-page opinion is. She, for all intents and purposes, rejected the views of Massad Ayoob. Now, for those of you who don't know Massad Ayoob, he is literally one of the foremost experts in deadly force and using firearms for self-defense, literally in American history, certainly in the 20th century and the 21st century. He goes back decades. And I learned so much from him just watching his videos on YouTube, and I've read his books over the years, and simply he is the best. He has trained thousands upon thousands of various people, including law enforcement, which means that people have written checks and put in their lives on the line, right? They've literally have said, Massad Ayoob, we're going to give you money, either as police officers or civilians. We're going to pay you to tell us how to stay alive and how to follow the law. He's done this thousands upon thousands, probably to tens of thousands of people is my guess. Nevertheless, here is what Judge Karin Immergut said about Massad Ayoob. Quote, "This court cannot give significant weight to the testimony of plaintiff's expert Massad Ayoob," period, close quote. She then goes on to say the reason why she can't do it is because he is a part of the Second Amendment Foundation and so on and so on. Now, come on. There is nobody in that courtroom that knows more about self-defense and the use of firearms than Massad Ayoob. And the fact that this Judge Karin Immergut refused to credit his testimony just shows you that you were in effectively a kangaroo court as far as I could tell. And frankly, I think I've said this on prior videos, even when these terrible anti-gun judges ask the Second Amendment plaintiffs to bring on various expert witnesses and whatnot, it's a waste of time. Legally, you don't need it. And you're going to get crap like this. So don't cater to the anti-gun judges, for those lawyers out there. Even if they're begging you to bring on experts, you know the outcome and you don't need it. And we're going to talk about why you don't need it again in just a moment when we discuss some interesting findings by Judge Karin Immergut in just 1 second. But now you understand what we're talking about. We're dealing with a judge that worked with the ATF as a prosecutor for DOJ for multiple years, and she couldn't even credit the testimony of Massad Ayoob, literally one of the world's foremost experts in firearms self-defense, and he can prove that by virtue of all the people that have given him money for training. I probably should get trained by Massad Ayoob, but I've never done that. I've never taken one of his courses, but I have to tell you, I really would like to one day. Nevertheless, let's get into the legal details now. Now, right off the top, we win this case based on Judge Karin Immergut's views. This is what she found, and tell me if you think this is enough to win. She says, based on the parties' pretrial stipulation, this court finds that millions of Americans today own large capacity magazines. Hello? The uncommon use test set forth by Heller, which is a gun ban case, and this is an arms ban case, says that if an arm is in common use today by Americans for lawful purposes, it's protected, period, full stop. So here we have a finding by Judge Karin Immergut that millions of people own these. It's protected. This is game over. This is all she had to do. She made this finding on page 25. She could have stopped there and not go on to the extra 122 pages that she added onto this thing. But she didn't. Why? Because she said that these magazines are not arms. Now, to quickly go over why magazines are obviously arms. Number one, we know from Supreme Court precedent, including quotes from Clarence Thomas, that just like, let's say, ink is protected under the First Amendment, because you need ink to be able to exercise your right to a free press and your right to free speech, even though the word ink is not in there, that is a way you can facilitate your rights of free press and free speech. Likewise, paper is not mentioned in the First Amendment, yet banning paper to stop speech and press would be unconstitutional. And pens and internet access and so on and so on. All of this is necessarily implicated by the First Amendment, and all of this would be protected under the First Amendment. You can't prevent all this stuff that allows people to effectuate or facilitate their rights under the First Amendment. So too as the Supreme Court said in Nysurpa versus Bruin that says, items that help facilitate self-defense, and that's the key word, facilitate self-defense, are protected arms. Well, obviously, magazines help facilitate self-defense, among other lawful uses of firearms, because that's how you're able to fire the gun without having to reload, because otherwise we're left with a single shot revolver. And that's where the anti-gunners want to go, right? Because if they can say that we can tell you how many rounds you can have in your magazines, today in Oregon it's 10 rounds, tomorrow will be 9 rounds, the next mass shooting somewhere will be 6 rounds, and then next thing you know, we'll all be left with single shot revolvers or single shot pistols, which is of course where the anti-gunners want to take this. Nevertheless, Judge Immegart said that magazines are not arms. They're not needed because she says that some magazines might be needed, but magazines that hold more than 10 rounds are not needed. But here she runs smack dab into a mistake made by the District of Columbia in Heller. Because as you recall, the Supreme Court said in Heller to the government, quote, "It is no answer to say, as the District of Columbia government says, that it is permissible to ban the possession of handguns so long as the possession of other firearms, i.e. long guns, is allowed." The point is that Judge Immegart was making this exact same mistake and ignoring Supreme Court precedent by saying, hey, you can have magazines that hold up to 10 rounds. So therefore, the government can ban magazines that hold more than 11 rounds. This runs smack dab into Heller, because what basically Heller said is the government cannot say, hey, we can ban that arm over here because we're letting you have the other arm over there. In this case, they're saying we can ban magazines that hold more than 10 rounds because we're letting you have magazines that hold 10 rounds or less. That is not an argument under the Supreme Court precedent, and why an inferior court in Oregon would violate this law is either because she did it on purpose, or she can't read, or she didn't bother to read the Supreme Court precedent of Heller. Now, here's the thing. Heller is the case that you apply for arm ban cases. Arms ban, gun ban cases. So one thing she tried to do to sneak around Heller, on purpose or because of out of ignorance, I don't know. She says basically this is not an arms ban case because magazines are not arms. But we know that they're arms because they're needed. She admits that they're needed for some arms. And we know that as long as they're needed for some arms, those are protected. And of course, Americans overwhelmingly selected these. That's why there's millions of them out there. And keep in mind that Heller says that modern firearms, right? Modern firearms are protected arms. Specifically, the Supreme Court says, quote, whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition on their use is invalid. Right? So basically what the court was saying there in Heller is that modern firearms are protected arms. Now, this is reaffirmed by none other than Justice Sam Alito on the Supreme Court in the Caetano case, where this is what Justice Alito said. And you'll see why this is very interesting, because strangely enough, Judge Karin Immergut relied on the same opinion, but not the right part. So this is what Sam Alito, Justice of the Supreme Court, said, quote, in the Caetano case, which dealt with a ban on stun guns. While stun guns were not in existence at the end of the 18th century, the same is true for the weapons most commonly used today for self-defense, namely revolvers and semi-automatic pistols. Semi-automatic pistols were not invented until the end of that century. The point being that Justice Alito is pointing out that semi-automatic pistols are protected arms because they're modern firearms protected under the Heller case. Now, what makes a semi-automatic pistol a semi-automatic pistol? Obviously, a major part of it is the magazine, whether it be fixed or detachable, that allows it to fire multiple rounds without reloading. So obviously, it is protected because it is a component of a modern firearm, which of course are protected because just like we protect, as the Supreme Court has said repeatedly, just as we protect modern technology under the First Amendment, like you can use internet, phones, radio, TVs, and whatnot to exercise your right to free speech and right to free press, using modern inventions that didn't exist at the time of the founding, so too can use modern firearms, modern firearm technology, which is basically semi-automatic firearm technology. And that requires, of course, the use of a magazine. And even if it doesn't require it, which it does, even if it doesn't require it under Bruin, it helps facilitate self-defense, so it's still protected. Now, before I move off this Justice Alito point in Caetano, what's ironic is that despite that language about semi-automatic pistols being protected, which means by definition magazines have to be protected because they're an essential component of semi-automatic pistols, and Karin Immergart's reliance on Sam Alito's concurrence in Caetano, which she skipped over the key language I read. So what is she? But she still relies on Sam Alito's opinion in Caetano, which means she actually read the opinion, but conveniently ignored the part that's damning to the point she's trying to make, which is these magazines are not protected arms. That's what she's trying to prove. So she conveniently ignores the language I just gave you, which shows that they are because they're part of semi-automatic handguns, semi-automatic pistols. But then she does quote Sam Alito on page 65 of her 122-page decision. Boy, the work I do for you guys out there in the internet, it's a pain in the butt. Nevertheless, we have to do it to save our rights, and that's why I do it for all of us, including you guys, of course. So here's what she writes in footnote 25. She writes about the Caetano concurrence, quote, Justice Alito wrote that the individual right to keep and bear arms vindicates the basic right of individual self-defense. So she's quoting Sam Alito, Caetano decision, in footnote 25 of her opinion, but conveniently ignores the other part of that, the same exact decision by Justice Alito that says semi-automatic pistols are protected arms, which means by extension magazines are. Now, the last point I want to make, and this is a slam dunk point, and this is absurd that Judge Karin Immergut got this wrong. She says that banning magazines that hold more than 10 rounds is not a gun ban, and therefore Heller doesn't apply. So this is very important. I want you to pause for a moment, guys, and think a lot about what I'm about to say. Judge Karin Immergut says that banning magazines that hold more than 10 rounds is not a gun ban, and therefore the Heller in common use test, which we clearly went on, is not applicable. This is silly, but you have to think a little bit, which may not be something that happens out there in Portland as much as it should. Here's how to think about it, though. If a law bans magazines that hold more than 10 rounds, what have you done? You have banned an entire class of firearms. How so? By banning magazines that hold more than 10 rounds, you have banned firearms, an entire class of firearms that are able to hold more than 10 rounds. Any firearm that holds more than 10 rounds has been banned, which means you have banned a class of firearms, i.e. firearms that can hold more than 10 rounds. It is indeed a firearm ban when you ban quote-unquote large capacity magazines. It is not just a magazine ban, it is a specific firearm ban on firearms that can hold more than 10 rounds. It is a specific firearm ban as well. For all these reasons, the Heller in common use test applies. As she's already said in her finding, which is a no-brainer because we know it's true, millions of people have these magazines that hold more than 10 rounds. They're the most common out there. Guess what? They're protected under the in common use test. Game over. But Judge Immergut couldn't even be bothered applying Heller. She wanted to run down all this Bruin stuff. Now, the next major mistake that Judge Karin Immergut makes is that she spends all this time talking about firearms technology, the history of it. Doesn't matter, right? The Supreme Court has already said that modern firearms are protected arms if they're in common use, right? So basically what she's done is she said that magazines that hold more than 10 rounds are dangerous and unusual. Did you hear what I just said? Judge Karin Immergut says that these magazines are dangerous and unusual. But guess what? It can't be dangerous and unusual because she's already made a finding that the parties agreed to because they had no choice because it's obviously understandable that guess what? These magazines are owned by millions of people. There's millions upon millions of these out there, which means by definition it cannot be dangerous and unusual because it cannot possibly be unusual. Hello? How hard is this? I mean, I don't understand. Unless you're not trying. And I suspect that she's trying, but not to follow the Constitution. But she's trying, but not to follow the text of the Constitution. That's my guess. That's my speculation. Based on what I read on this 122-page decision that I was forced to read, with all these dozens of footnotes, which I was also forced to read, and I did. But let's continue on. So the point is she talks all about this history. She admits that these are in common use, but then doesn't apply the relevant standard because she says it's not a gun ban. In case all of this, of course, is false for the reasons I've get forth. Then she plays a little cute game. Okay, now at some point we're going to talk a little bit more about legislative facts versus adjudicative facts. We've talked a little bit about this in the past, but I don't want to dwell on this because this is super inside baseball geekiness and it's completely unnecessary. And I'm going to make it really short and tight here. Now, just to show you how absurd and ironic this decision from Judge Karin Immergut is, she contradicts herself internally. Okay? So, let's start with what the Supreme Court said in Heller, as described by none other than Judge Immergut. This is what she writes on page 59 and 60 of her 122-page decision. She writes, quote, Bruin itself declined to clarify the metric by which courts should determine whether a firearm is in common use, blah, blah, blah. But here's the key part. The Supreme Court repeated Heller's observation that the Second Amendment protects the possession and use of weapons that are in common use at the time, and found, without identifying any particular evidence, that handguns are weapons in common use today for self-defense, citing to Bruin, which in turn cited to Heller. Now, I want you to listen carefully to this because it's extremely important to just show the absurdity and hypocrisy of this decision by Judge Immergut. So on page 59 and 60, she literally points out that the Supreme Court in Heller and Bruin found that handguns were in common use in America in the 21st century today, which is no brainer, we know they are, and goes on to say, this is the key language, you litigators out there, and found, quote, without identifying any particular evidence that handguns are weapons in common use today for self-defense, period, close quote. That's what the Supreme Court did. Now, the reason why this is significant, it just shows that the entirety of this trial, which apparently was ordered by Judge Immergut, was unnecessary. Because what Judge Immergut is, if you look at this 122 pages, she talks all about all this testimony and all this trial evidence and all these experts and all this stuff as if you're trying to figure out whether or not someone went through a red light. As if you're trying to figure out whether or not someone, yesterday committed fraud in a business. When all you're really trying to do when you're dealing with the Second Amendment cases dealing with gun bans is ask yourself, are magazines in common use by Americans for lawful purposes, yes or no? This is understood, right? This is not adversarial in the sense these are all what are known as legislative facts that everyone understands. So, for example, if everyone on the planet knows it rained in your town yesterday because the government and the meteorological services said it rained and it's in all the records, you don't need to try a case on that. You don't need witnesses on that. Government documents suffice to prove the point because everyone knows it's to be true. It's what's known as a legislative fact. You don't need experts. And the best evidence of that is pointed out by none other than Karin Immergut here, because here's the question. Do you know how many experts testified in the Heller case about handguns being in common use and about handguns being used or not being used for self-defense? Do you know how many experts testified in the Heller case in total? Zero. None. Nada. Zip. Zilch. None. Zero. So here you have Judge Immergut quoting and acknowledging that the Heller case, which the Bruin case then quotes favorably, finds that handguns are in common use today without identifying any particular evidence because it's not needed. Everyone understands it. You don't need to know who. It's not a he said, she said case in behind some closed doors somewhere where you need to take on testimony. You don't need that. And yet Judge Karin Immergut insisted upon this at who knows how much this cost the litigants and the headaches associated with it. And it was totally unnecessary. And she knew it was unnecessary. And you know why we know she knew it was unnecessary? Because she actually says it was unnecessary in her own opinion. If you look at what Judge Immergut wrote in her footnote number 2 on pages 9 and 10, it actually contradicts what she says on pages 59 and 60. Because in her footnote, she says, plaintiffs did not identify any non-hearsay purpose or exception to the rule. I'm not going to bore you with the technical evidence stuff, which we can get into at a separate video. The bottom line is, she's like that legislative facts or these common sense facts that everyone understands were not appropriate for this case, and she couldn't use them because she's a trial court. All rubbish. Rubbish. And that's not me saying it. It's actually Judge Immergut saying it on page 59-60 of her own opinion. Her footnote 2 contradicts what she says on page 59 and 60, and she probably didn't understand that she did exactly that. Because everyone understands that semi-automatic handguns are ubiquitous, that these magazines are ubiquitous, that these handguns are ubiquitous, that AR-15s are ubiquitous. They're everywhere. Everyone gets it. That's why the anti-gunners try to ban them, because they're quote-unquote too many. You don't need to try a case on that question. It's a given. You certainly don't need expert testimony, because here's the bottom line. If the U.S. Supreme Court did not need expert testimony or any testimony in Heller, and by the way, do you know how many people testified? How many experts testified in Bruin? 0. So you have nobody. And how many experts testified about firearm technology in Caetano? 0. No experts, no testimony in Heller, no experts, no testimony in Bruin, no experts, no testimony in Caetano, and yet you have this inferior court out there in Portland, Oregon. Judge Karin, Immergut, insisted upon all this crazy testimony. Silly, wrong, mistake, goofy. Yes, judges get to make their own decisions when you're at a trial court. Do whatever you think's appropriate, but not necessary. And she acknowledged that it wasn't necessary in her own opinion. Nevertheless, that's what these Second Amendment plaintiffs were up against, as I can see. It looks like a dead dog loser from the start, which is what I predicted. Nevertheless, they went through the motions, and here we are. Now, let me carry on. The last point I want to make is another major mistake by Judge Karin Immergut. And that is, she tried to use the quote-unquote excuse to sneak around current Supreme Court case law by saying that mass shootings are a new phenomenon and unprecedented, and therefore she can make stuff up. That's basically what she did here. But it's all not true. Not true. To begin with, mass shootings are not new as a general matter. Number one, we know that at the time of the founding, you had the Boston Massacre, where British soldiers killed 8 Americans, mass shooting. We know that the Indians had a massacre at a school where 12 people were killed, including Enoch Brown, the headmaster in Pennsylvania, before the Revolution. So mass killings, mass shootings, not new to the Founding Fathers. Those all occurred before the adoption of the Second Amendment. This was understood to always, this mass killings, not new. Not to forget, of course, in England, the Founding Fathers were also aware of what was known as the Gordon Riots. In the Gordon Riots in London, 650 people or so were killed in the Gordon Riots. All this stuff was understood by the Founding Fathers when they adopted the Second Amendment. So to say that mass killings were a new phenomenon in the 21st century, simply stupid, not true. Nevertheless, let's just be more modern about this question. So what Judge Karin Immergut's trying to talk about is that these mass shootings with guns, modern-day guns, are somehow a new phenomenon. Also not true. Now let me give you the bottom line. Let's think about this for a second. In 2008, the Supreme Court decided the Heller case that said that modern firearms are in common use. If they're in common use by Americans for lawful purposes, they're protected arms, period, full stop. No interest balancing test. No guns versus guns are bad. None of that stuff mattered to our Second Amendment rights. What happened in 2007, 1 year before the 2008 Heller case? In 2007, a single man uses semi-automatic handguns with magazines that held more than 10 rounds, killed 34 people at Virginia Tech in 2007. Nevertheless, in 2008, the Supreme Court issued their Heller decision. Nevertheless, in 2022, the Supreme Court issued their decision in Bruin, where they used this reference to unprecedented social change and different societal things and like that for the purposes of discussing analogies that should be applied outside of the context of gun ban cases, because they reaffirmed Heller like 80 times in Bruin, which is how you handle bans on arms. And again, these bans on magazines are arms ban cases for the reasons we've gone over. Nevertheless, Judge Immergut tried to say that these mass shootings are new and therefore she can make stuff up. That's basically what she said. But again, not true. The Supreme Court was well aware of them in 2008. They're well aware in the Bruin case. There was discussions of mass shootings in the Heller case as well. And the Supreme Court understood all that and set forth the law of Heller, reaffirming Heller in Bruin. Nevertheless, Judge Karin Immergut did what all these other anti-gun judges do, and that is, of course, use the language from discussing how you apply analogs buried in the context of Bruin to somehow override Supreme Court precedent and think they're smart. But they're not smart, they're not doing right, and they probably know they're not doing it right. But nevertheless, assuming that they're trying to get it right, Judge Immergut clearly did not. All right, folks, I hope you learned a little bit something here today. We'll talk more about this case and other related cases, but I don't think this is the end of the line. And by the way, for those of you in Oregon, it's my understanding that right now there's a state injunction still in place, so I don't even think this law has gone into effect yet because it's been enjoined by the Oregon state courts. Again, we'll see what happens. I'll keep you abreast as I continue my reporting on this. But in the meantime, hope you learned something. Make sure you subscribe. I really am trying to build my subscriber base here. I'd appreciate your help. And if you haven't done so, please do so. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.